There are three different types of intellectual property: copyrights, patents, and trademarks. Each type of intellectual property protects a different aspect of your business. So with patents, those are typically for inventions like new technology. With copyrights, that's for art and literary works like books and movies. And trademarks, which is what we're going to cover today, are basically the brand for your goods and services, like the Nike swoosh. Sometimes a business needs protection for all three types of intellectual property, but today we're going to focus on trademarks. So a trademark is an essential part of your business. It's essentially the brand of your business. It's your goodwill and it's your reputation. It's going to be the mark that distinguishes your products or services from that of your competitors. So the legal definition of a trademark is a word, phrase, slogan, symbol, or design or combination thereof, which 1, identifies the source of the goods and services, and 2, distinguishes your goods and services from that of others. So essentially, the trademark is your brand. For example, imagine the Nike mark and the Adidas mark. When you go into the store and you want to buy a Nike pair of shoes, by looking at the mark, you automatically know that that's Nike as opposed to its competitor. That way, if you wanted to buy Nikes and not Adidas, you can, and vice versa. Registering a trademark means that you've received a registration certificate from the United States Patent and Trademark Office. It's not the same as registering a website domain name. In fact, if you register a website domain name that accidentally includes the trademark of another person, you may actually have to surrender that website domain name. So again, just because you have a website does not mean that you have the federal protection of a trademark. So let's talk more about the benefits of federal registration of your trademark. Technically, a trademark is created through use in commerce. That means as soon as you have a brand and you begin to sell your product with your mark on it, you have use-based rights as a trademark. The thing is, a use-based trademark is limited in geographical scope, and it's also really hard to put others on notice that that's your mark. With federal registration, you greatly enhance your rights. First, federally registering your mark creates a legal presumption that you are the owner of the mark. That means if there's a dispute or you end up in court, you don't have to prove that that's your mark through a use-based evidence. It's presumed based on the fact that you have the certificate of registration. Second, your mark is listed on USPTO's online database. That way, everybody's put on notice that that's your mark and other competitors won't use a mark that's similar or the same as yours. Also, it gives you the actual right to bring a federal lawsuit if you find that another company is infringing on your trademark rights. And, really fun, you have the right to use the R with the little circle symbol on your products. So now that we know the benefits, how do you get a trademark? So in the United States, applying for a trademark is actually considered a legal proceeding. So you would have to file an application and then receive the certificate of registration from the USPTO. The application has to meet pretty strict legal requirements as well as strict deadlines that you want to make sure that you're complying with in your application. But here are the basic steps. First, you file the application either under Section 1A, Use in Commerce, or 1B, Intent to Use in Commerce. That basically means that even if you haven't started using your trademark, you can still begin the trademark application process as long as you eventually are able to prove before the process is over, which can take months, that you have started to use that mark in commerce. Next, your trademark application will get sent to an examining attorney. They're going to examine your application and make sure that there are no issues. Now, if you have no issues, your mark is then published for opposition. That means the public has a chance to oppose your mark if they feel that it's infringing on one they already have. If nobody opposes your mark, then the next step is that you get your certificate of registration. Now, if there are issues on your application, you're going to get something called the office action. It's going to cite the defects. It's going to give you 6 months to reply and to fix the issues in your application. If you reply in an adequate fashion and in a timely manner, then you're going to go ahead and go again to the step of publishing an opposition. If there's no opposition, you get your trademark. Now, if you fail to reply adequately or fail to reply in time, then your trademark application gets abandoned. You lose your fee that you paid to submit the application, and you have to start again from scratch. So let's talk about some of the most common pitfalls you want to avoid in submitting a trademark application. The first one is the likelihood of confusion. You want to avoid selecting a mark that's deceptively similar or the same as a mark that's already registered with the USPTO. Luckily, you can easily search the USPTO's online database and make sure that you're not picking a mark that somebody else is already using and has registered. The second and more nuanced pitfall is what we call the strength of the mark. You want to pick a mark that's very strong in order to ensure that you get approved on your application. When it comes to strength of the mark, you want to think of it on a spectrum. The strongest types of marks are called fanciful and arbitrary. They basically mean they're random. They have no association really with the product that you're selling. Think Apple for computers. Or it could even be words that don't even exist until you've created them for your product, like Pepsi for soft drinks or Kodak for photography. At the bottom of the spectrum, you have generic words. Words that are obvious, and these words are not even registerable on their own. So for example, milk for dairy beverages. And descriptive words are also at the bottom of the strength spectrum. Words which directly describe the product. So for example, American Airlines for an American airline company. Now, the reason American Airlines can still have that trademark is because the only way that a descriptive word can become a trademark is if there's a really strong use in commerce that has made it into a brand. Otherwise, you're going to want to avoid these kinds of descriptive words. Now, there is a middle ground where you can be pretty warm and still get your application approved. And these are suggestive words. They don't describe and they're not simply generic, but they do suggest certain qualities about the product. So for example, public eye for a tabloid magazine or Netflix for movie streaming. So remember, the trademark is the brand for your business. It's going to help distinguish your product from other competitors, and you're going to want to select a mark that is strong, meaning fanciful or arbitrary. You don't want to cause confusion with another mark, so make sure that you look up on the USPTO's online database that it's not already registered to another person. Now, while it's not required, the USPTO does highly recommend that you work with an attorney that does trademark law. If you can't afford an attorney, then be sure to visit the USPTO's online website for a lot of free resources on how to get your application processed and approved.